Hi, good afternoon, everybody. My name is Shihan Kim at the Housing Alliance Pennsylvania, and thank you for joining us today at this webinar. I'm just going to give a few more minutes for people to come in. Good afternoon, everybody. Let me just give it one more minute for people to join before getting started, but thanks for being here. All right, why don't we get started? So thank you for being at this event today. My name is Chihan Kim. I'm the Research and Education Manager here at the Housing Alliance of PA. And I just wanted to go through some of the basic introductory stuff before we get to our presenters today. So welcome to today's webinar. The Housing Alliance of Pennsylvania is a statewide coalition working to increase access to safe, decent, and affordable homes for all Pennsylvanians. We work to fulfill our vision for home within reach through state and federal policy advocacy, opportunities to connect, share, and learn from your peers, events, and our annual Homes Within Reach conference. If you aren't a member yet, we ask that you consider joining. You can visit our website to join as a member, or you can contact info@housingalliancepa.org for more information on membership. Today's webinar will be approximately an hour, including question and answer. If you want to ask the presenters a question, please use the Q&A feature at the bottom of your screen there. The arrow is pointing to it. The chat function we ask to reserve for asking any logistical questions about the webinar. For any questions you'd like to pose to our presenters, please use the Q&A feature. We will email you a recording of this presentation and any associated materials or resources in approximately a week's time. Before we get started, I wanted to let you know of some upcoming events. Next Tuesday at 2 p.m., we actually have another utility-related event or energy-related event. We will host a special online event with representatives from each of PA's electric utilities on what energy efficiency programs are available for multifamily housing and how those programs can benefit housing providers and tenants. We will have breakout groups for each utility so that attendees can speak directly to the utilities and efficiency service providers about how they can benefit from these programs. Please visit our events page to register. The Housing Alliance will be holding our 18th annual Homes Within Reach conference this year in Hershey, Pennsylvania, December 7th to 9th. The theme for this year's conference will be A Stronger, More Equitable Tomorrow. The conference will be at the Hershey Lodge in Hershey, PA. I also wanted to let you know of some recent Housing Alliance resources. We've updated our county by county fact sheets for 2022. These housing needs snapshots, as we're calling them, are one-pagers that provide an at-a-glance look at the need for more affordable homes in each county. You can find them linked from our front page. Finally, on our website, you can find our 2022 policy agenda. So the budget that passed last week included some really important wins, like $125 million in funding for the whole home repairs program and $150 million for affordable housing construction cost relief. You can check out our policy agenda page for our priorities for the remaining year. And with that, I would like to introduce our speakers for today's event. Gio Brackbill serves as the Utility Justice Project Manager at the Pennsylvania Utility Law Project, where she works on outreach projects to address and alleviate the unique barriers to utility service faced by historically underserved communities, in furtherance of the mission to ensure that low-income customers can access and maintain safe and stable utility services. Lauren Berman serves as a staff attorney at Pulp. She provides direct representation to consumers and legal support in utility and energy matters affecting low-income residents and community organizations in Pennsylvania. Gio and Lauren will provide an overview of the current utility assistance landscape, statewide resources to assist people having trouble paying utilities, and how to protect individuals and families from the loss of utility services. Our presenters will cover eligibility requirements and deadlines, common misconceptions and barriers, consumer and tenant rights, and more. Thank you so much, Gio and Lauren, for joining us today and sharing your expertise. I'll invite you to turn on your cameras and hand over the floor to you. Thank you.
Thank you so much for the kind introduction. Lauren and I are both pleased to be presenting for the Housing Alliance of Pennsylvania today through our webinar titled Utility Assistance, What You Need to Know. As it was said, I'm Gio Brackbill, I'm the Utility Justice Project Manager, and my co-host Lauren Berman is a staff attorney at Pennsylvania Utility Law Project, or PULP as we call ourselves. Next slide. So what we do at PULP, we're statewide specialty legal services program in PA. We're based out of Harrisburg, but currently both still working remotely at this time. Our mission is advance just and equitable access to safe and affordable utility services for Pennsylvanians experiencing poverty. And we work to achieve this mission through empowering individuals and communities. We do direct representation, education, like today through webinars, advocacy, and community-led coalition building. Next slide. Our agenda for today is first we're going to talk about the difference between regulated versus unregulated utilities. Then we'll discuss utility affordability and preventing termination. Then we'll move along to connecting and reconnecting to service, discuss tenant protections a little bit and the dispute process through the PUC, and end with some resources and referrals for everyone. Okay, so the difference between regulated and unregulated utilities. So our first group of regulated utilities, these are mostly the large electric and natural gas and water companies that are subject to the Public Utility Commission jurisdiction, or the PUC. Consumers can file complaints through the PUC, and these regulated utilities have to follow the rules and regulations for billing, collections, and terminations. And then all of these regulated gas and electric utilities are required to have universal service and energy conservation programs that are designed to assist their low-income customers or households to maintain and afford service. Most of the large regulated water and wastewater utilities also have some variation of these programs, and I will discuss these programs, the CAP, LIHEAP, CARES, and Hardship funds. Sorry, I know there's a lot of acronyms, but I'll discuss them later in the utility affordability portion. With regard to unregulated utilities, on the other hand, these are your municipal utilities or electric co-ops, with the exception of Philadelphia Gas Works and Pittsburgh Water and Sewer Authority. Consumers have to file complaints through the Court of Common Pleas for these, and although they must follow the Water Services Act and the Utility Services Tenants' Right Act and other broad consumer laws, they don't have standard billing, collections, and termination standards. And there's also no requirement for them to offer these assistance programs and payment arrangements that I discussed before. So first, we are going to talk about the utility run assistance programs, and then I'll move along to discuss some of the other federal programs. Our first bucket is CAP, customer assistance programs. Now, every utility might call this something different, on track, PCAP, CRP, but these are available to the consumers of these large regulated gas and electric companies, and some of the water companies, like I mentioned before, Aqua, PA American Water, and PWT, do offer these assistance programs. The benefits are that a customer will get reduced rates and lower monthly payments based on their income. They can have forgiveness of their past debt or arrearages. They'll be frozen when they enroll and then forgiven over each on-time payment over time. To be eligible, they have to have household income below 150% of FPL, and they will be subject to periodic income verifications. To enroll in these programs, the utility may ask for their social security number, but it's not required. Next bucket would be LIHEAP. So this stands for Low Income Usage Reduction Program. The benefits of this is that they can go through an energy audit and be given the provided with appropriate energy conservation measures. So this might mean replacement of the refrigerator, heating system upgrades, or other appliances. This can include weatherization measures like insulation to reduce the energy burden in the household, and then also improving the LED or power strips and all of those types of things. Eligibility for this program is at 150% or 200% FPL, depending on which utility it is. The other requirement is that the household has to have high usage, and if they are tenants, get landlord approval to participate in the program. And the CAP program that I mentioned before, those who enroll in the CAP program may be required to participate in LIHEAP at the utility. The next program I will discuss are the Hardship Fund programs. So these are, the benefits of this is a cash grant applied to their utility account, and this is typically up to $500 to resolve a crisis. Again, these eligibility requirements are going to vary depending on which utility it is, but typically the eligibility income level is 200% FPL or below, and they had to have made a recent payment or attempt to make a payment. They call this a good faith payment attempt, and the utility may make exceptions if they weren't unable to make recent payments, but you do have to ask if you're advocating on behalf of a client. The other requirement is that they're facing a temporary hardship in the household and that the grant must resolve the problem. So if they do have more than $500 in arrearages on their account, you may have to get a little bit creative and combine some of these programs or work with the utility a little bit more to help resolve the problem. Last, we'll talk about CARES. It's a little use program, and the utility has wide discretion to help resolve the customer issue. So like I mentioned with the Hardship Fund program, sometimes you have to combine different assistance to help your client. So the CARES program is also for those who are having trouble paying their bill and might be having more of a short-term problem that's causing inability to pay. And they don't have that household income requirement, but they do offer this for example, if you have a client that might be a survivor of domestic violence or have some other issues that would qualify them for this program, this is a good one to look into. They'll get refers to other social service agencies, budget counseling, and some special arrangements for bill payment. The next part that we'll talk about are some of the federally available programs. First is Lifeline. So this is a subsidy for telephone, broadband, or bundled service, and it can't pay for the equipment, but sometimes providers will offer a free telephone. It's portable to other providers, and there's only one subsidy available per household. For eligibility for this Lifeline program, they have to be at 135% of federal poverty level or below, or have some other categorical eligibility. That can be through receiving SNAP, Medicaid, or other benefits that are listed there. And then we are going to move along to the Affordable Connectivity Program, or ACP. Now this, you might be familiar with this because it replaced the Emergency Broadband Benefit Program. The benefits are that there's up to $30 a month in a broadband subsidy, and some providers will provide a device discount of up to $100 with a $10 to $50 co-payment. So also, households to qualify need to have incomes below 200% of FPL or be enrolled in SNAP or a host of other benefits programs. And there's expanded eligibility through ACP that wasn't necessarily available through EBB. The next program that opened just this year on January 4th, 2022 would be the Low Income Water Assistance Program. So this provides up to $2,500 for water and up to $2,500 for wastewater services. And to be eligible, the customer just has to be 150% of FPL or below. They need to show that they have water or wastewater responsibility. And that doesn't necessarily mean that their name has to be on the bill, but if they pay this, if they're a tenant that pays this portion of their rent, they can still apply for this. They do need to be in a crisis, so at risk of termination, or the service is already off to the home. And this will guarantee that the utility agrees to maintain service for a minimum of 90 days after the grant is received for them to qualify. Funding is anticipated to run out for this program very shortly this month. And in order for it to continue, additional program funding needs to be allocated.
I'll just jump in really quick that we are still referring people to the program, and so far there still does seem to be funding, but we are just aware that this is not an ongoing or recurring program like LIHEAP.
Right. Thanks, Lauren. Another temporary relief programs, other temporary relief programs that are going on right now would be the emergency rental assistance program. We add utility in there because it also can be used for utility arrearages. So they have to be at or below 80% of area median income. Some counties are running out of funds from phase 1, and the eligibility for phase 2 is that they don't have to show a reduction in income or increase in expenses due to COVID. They just have to have been affected during COVID. And this phase 2 is being launched in several counties with a new round of funding, though some counties are fully spent as well. And like I mentioned, it's usually referred to as ERAP, simply as rental relief, but we want eligible renters to know that they can get help with their utilities, even if they've kept up with their rent. The other temporary relief program that's happening at the moment is the PA Homeowners Assistance Fund, or HAF. Homeowners have to be at 150% AMI or below, and this is primarily for mortgage, but then there's also eligibility for other related costs, and there's can be up to $8,000 per household for delinquent utility bills. Now we'll move on to LIHEAP, which most of you are probably familiar with. It stands for Low Income Home Energy Assistance Program. It's federally funded and administered by the Pennsylvania Department of Human Services. This usually runs annually from November through April. This can be applied through to a gas, electric, and deliverable fuel account or if a water account if it's required for heating, like for example, steam heat radiators. The types of assistance available are a cash grant and then also a crisis grant, which is for those who are experiencing an imminent home heating emergency. If they experience a crisis multiple times throughout the season, they can receive multiple grants, but they have to resolve the crisis. Also, another type of assistance available through LIHEAP is the Crisis Interface Weatherization grant. So this is through DCED, and this can be emergency heater repair or replacement. Also, there's always additional summer supplemental grants, and this year, DHS will be issuing 2 supplemental grants for 2021-2022 LIHEAP recipients to expend the remaining funds from this year's LIHEAP season. For those who applied before the deadline on June 17th, the first supplement will be $500. It'll be issued as a cash supplement for households that received a LIHEAP cash or crisis benefit to a deliverable fuel vendor. So that could mean coal, wood, oil, propane, or other deliverable fuels. And then the second supplement will be $250 to households that did not receive a summer fill supplement. So this one will be issued also as a cash supplement to the utility that received the most recent LIHEAP benefit. So both supplements are estimated to be issued in mid-August, and these supplemental grants are in addition to any cash and crisis LIHEAP grants that were received during the regular program year, and they don't impact the ability for households to apply for LIHEAP on November 1st when the 2022-2023 season opens up. Lastly, coming down the pipeline.
I'm sorry, before we move on, there's a good question here regarding the Homeowners Assistance Fund. Is there a requirement for the grant to resolve the issue like there is for, crisis or a hardship grant? Like, would applications be denied for utility bills larger than $8,000? I can take a swing at this.
Oh, sure.
Yeah. My understanding is that there is not that requirement. And I will also say it's incredibly rare that, it happens, but it's fairly rare that an individual household will have a utility debt of over $8,000. It certainly happens, we've seen it, but most of the debts that people at least come to us with, tend to be between the $2,000 to $4,000 range. So, I've had a couple clients who maybe would be over that amount, but I don't believe that there's any requirement in half that it completely resolved the issue. Another question was just asking about the resources generally, whether they are coordinated through any singular entity, and I think the answer is no. And Gio can probably expound on that.
Right. So these resources, depending on where they're administered through, you can have to apply, usually the Compass website is a good starting point for applying for these resources, but they're administered through social service providers throughout the state. Although I will note that if you do have a client who has, up in that over $8,000 range of utility assistance arrears, please reach out to us at Pulp. We're happy to do technical assistance or consultation to help you to provide advice to your client based on this. And we also have contacts at HAF, and we can help facilitate, advocacy on behalf of your client if you do have someone who would be eligible for that program. Sure.
Another general question here is, I'm going to combine these two. One is ERAP only for COVID related hardships? No, ERAP 2 funds just have to be hardships that occurred during the time of COVID, and you don't have to be able to point to a specific COVID related hardship. The other quick question was, are these programs underutilized at all? In my experience, the hardship funds are very underutilized, and CARES is underutilized.
Absolutely. I echo what Lauren said.
We do have a lot of questions here, so I'm gonna stop interrupting Gia. And when we she has a couple more slides, and then before I start my slides, I'll go through the questions that are there now. Okay.
Sounds good. Where I left off is I wanted to note that another thing coming down the pipeline was the summer cooling pilot. There's a budget for recipients of LIHEAP services during the last 2021-2022 crisis season. So these would be administered through the crisis interface providers through the WAP network. So that's the furnace repair program that I had mentioned. And they'll be working on installing ACs, fans, and repairing systems that are inoperable. If you're interested in LIHEAP in general and want to know more about it, I would encourage you to sign up for our newsletter, because I just put that link in the chat. We hold an annual LIHEAP webinar, and we will be sending that out for newsletters for people to register. We also have other resources that I'm going to also put in the chat that you may be interested in. We always do a LIHEAP annually that details all of this that I discussed. And last but not least, we have the Weatherization Assistance Program that's funded by the Department of Energy and administered by DCED. The eligibility for weatherization assistance is 200% of FPL or lower, and this is a priority for elderly, disabled individuals, families with children, and high energy users. They have to be a PA resident, of course, and if they're a renter, they need to get permission from their landlord to do this weatherization work on the house. This is expanding to multifamily buildings too, and there's going to be a webinar through Housing Alliance next week where some helpers will be also presenting on this extension to multifamily buildings. And there's also this weatherization assistance program helps those resolve health and safety issues to install measures in the home. I also wanted to note one last thing I promised before I pass it along to Lauren is that the budget was passed for the creation of the whole home repairs program. This was funded by 125 million ARP dollars, and this can provide up to $50,000 to repair, update, and adapt homes throughout PA. And these funds will support staff to help people access the assistance they need in order to get it, and training programs and stipends to build up the local workforce to meet the demand for weatherization assistance and repairs in PA. Oh, and as I promised, I'm going to put that other resource link in the chat.
Okay, well, she's working on that. Here, we do have some more questions here. So until what date can households apply to receive supplemental assistance during the summer? My understanding is that you get the supplemental grant if you got a LIHEAP grant during the regular season. So there is not a separate application process. And if you didn't get a LIHEAP grant during the regular season, there's really not an avenue to get a supplemental grant. Does that seem right?
So for those who applied for LIHEAP before the deadline, the extended deadline on June 17th, 2022, the DHS will just issue these supplemental grants to them. They don't need to go through a whole other application process for these.
And then we have our next question. Families with a college student, will they need to provide the college student's income if the student lives on campus? Great question. I'm not 100% sure, actually. For LIHEAP, I think what happens when you apply for LIHEAP is they'll run whatever you say your household composition is, they'll sort of run that against any benefits or anything else that have been received at the home. So if your child is living on campus but has received benefits at the home in the past, you may have to, just have a conversation with the LIHEAP administrator, provide their new address and explain the situation. I believe if they're there less than, if they're mostly not in your home, I mean, I don't know that they would apply, but Gio, do you have any more specific information on that?
No, that's accurate.
Thanks. Okay, two more quick ones. A client with a $9,000 bill and we'll be reaching out. Good. Yes, please have them call. We will give the hotline number at the end of the presentation. And then let's see. The LIHEAP summer supplemental grants were mentioned. This question, let's see, I have seen some social service agencies offering cooling grants to supply air conditioners and fans. I was told the funding was supplied by DCED to DHS. Do you know more about the summer cooling program, or if that's related to the summer supplemental grant? I don't think it's related to the supplemental grant is sort of its own, just sort of extension of LIHEAP, but I actually don't really know much about the summer cooling.
Right, so the summer cooling program is going to be administered very shortly. There were some through the WAP network that were still finishing up their crisis interface work, their jobs like furnace repair jobs, because there was extreme need for that this year. But there is going to be additional funding for the summer cooling pilot budget. Great.
And then how much is this supplemental grant, is it, what is it? I don't think we're 100% sure yet. I think 200, 250, or do we know?
If they are deliverable, if they receive LIHEAP for deliverable fuels, it's $500. That would be, you know, your coal, wood, oil, propane. And then the other one is $250. And these are ones that did not receive a summer fill supplement.
Great. And then how does one get financial assistance from ERAP without having experienced a loss of income related to COVID? Basically, you have to, it depends on the county. Some counties right now are only providing assistance if the applicant has an active eviction happening because they're just limited on funds. So that's some counties. Some counties aren't accepting any applications at all. The ones that are, you would need to show for utilities, you would just need to show that you're behind. So, you know, you have a shut-off notice, a past due notice, and it'll vary county to county on what those requirements are because they're administered very separately by their counties. And then for rent, yeah, you have to be behind on rent, or you can get rent paid forward up to 3 months in theory. But again, the funding is very limited at this point. So your best bet is going to be to, I mean, honestly, just Google like ERAP and then your county to get you to the right county agency. And then you need to look individually at each county on how they're prioritizing and what they have available at this point. And then rooming homes and immigrants, I'll talk a little bit about that in my section. So I'll just leave that for now. And then about how does one apply for the summer cooling program? That I don't know.
If you have a customer who is interested in the summer cooling pilot, please reach out to us because this is through the interface providers within the WAP network, the Weatherization Assistance Program Network. And we have a list of those by county, but we can help you with that depending on which county you're in.
Great. Okay, I will take over. So now we have an idea of what the landscape is, like what the programs are, what our situation is. So now the more practical side of how does this actually come into play with the people that you're assisting trying to maintain their service? See, I click on the one, there we go. So reconnecting service. So if you have someone that's moving or out on their own for the first time, typically the utilities will charge security deposits for establishing service, depending on the person's credit history or things like that. They, if you are below 150% federal poverty, you can have your security deposit waived. There are some exceptions to this. If you've had recent terminations, they may then be able to charge you a security deposit to get your service restored. But having your income on file with the utility is always a good idea, because if you are upfront with where that client is at, they may waive the security deposit altogether, which is what you want. If someone has arrearages, past due debt that are over 4 years old, the utilities can't require payment of that in order to establish service. So it's sort of like your statute of limitations on that debt. So anything older than 4 years can't prevent establishing service in your name. There are specific protections for people with a PFA or other court order showing clear evidence of domestic violence. That language is the language that is in the statute. So it's a little bit vague. We know that an active PFA provides these protections. The other court orders is a little questionable. So there's not really specific things where I have a case right now that we're sort of trying to figure out what paperwork is going to be sufficient for this client. So the protections, so generally speaking, in a home that does not involve any domestic violence, if you have 2 adults living in the home and the service is in the name of one of the adults, the other adult is also going to be responsible for that debt because they are an adult member of that household. So if that person moves to another place and tries to establish service, that debt may come with them if the other account is closed, right? So the exception that they make is for people that have a PFA or other court order. they can't be held responsible for or have their service terminated for the debt accrued in another person's name. So if the account was in the name of the abuser and the person with the PFA is either trying to move out and establish service at a new place, or the abuser has left and they're trying to switch service to their name at their current address, they can't be held responsible for debt accrued in the abuser's name. That the utilities are then also permitted to provide more flexible payment arrangements based on individual facts and circumstances. For example, if the abuser was the primary breadwinner, and so now the household has had a significant drop in income, certainly that would be, an individual factor circumstance that you would want to advocate with the utility. I always recommend making sure that if you do have a client with a PFA, that you provide that to the utility. There are certainly, privacy protections in place. They do take this pretty seriously. So it's, there are benefits and exceptions that can be made. And then there's also additional notice for customers with the PFA. So they have to attempt personal contact. And then if they can't attempt personal contact, the notice would be posted at the property and they delay another 48 hours. It just gives that person a little extra time. And then preventing termination. So the rules on termination, so these apply to regulated utilities. Those notice requirements apply to regulated utilities, not, your municipal water authority. That we'll talk about that a little bit later. But so terminations can only occur Monday through Thursday. So no Friday termination. Sometimes you'll get a termination notice that has a Friday date. It's just because they're automatically generated and it's just counting out the certain number of days. If you get a termination notice with a Friday date, consider the date the following Monday. And so these terminations have to be because of non-payment of an undisputed delinquent account. We'll talk about that in a little more detail. Failure to comply with terms of a payment agreement, which basically means you entered into a payment arrangement and fell behind, to pay the full security deposit amount, which again, if you're below 150% FPL, you can get waived, and permit access to equipment, which is not an issue we run into frequently. The notice requirements, and again, these apply to the regulated utilities. You need written notice at least 10 days before termination. That notice is effective for 60 days, meaning someone can get a termination notice dated for, July 1. They can get shut off all the way basically until the end of August. And then personal contact 3 days prior to termination. That's usually a phone call. If you've consented to get either e-billing or electronic notices, it may come via text or email. And then there's the last knock rule. So they must attempt personal contact with the residents immediately prior to termination. Frequently, we hear that this does not happen, which is not particularly surprising. The issue with the written notice requirements and phone calls, I feel pretty confident in saying that those do happen. It's basically all automated. We do have clients that don't get the notices because mail in a lot of places can be delayed, or they get the notice just a couple of days before the shutoff date. So that, it's, is it fair? No. But as far as the, utility commission is concerned, as long as the utility is sending them out when they're supposed to, they're kind of covered.
And Lauren, we
So yeah,
about DV survivors. So they asked if the debt's accrued in the survivor's name, but the abuser is the breadwinner. Can the utility put the debt in the abuser's name, or would it be on the DV survivor to make a payment plan?
Right. So in that situation, yeah, the utility would not be able to put the debt in the abuser's name. However, what they could do and what they should do would be willing to work with the client to, figure out a reasonable payment arrangement that they would actually be able to keep up with. So I would just try to get an extended payment arrangement in that case, because they won't put the debt in someone else's name, even if they're the breadwinner. But report the change of income. If there's a PFA, provide that to the utility, and then see if you can get something up to like a 60-month payment arrangement, or even a 72-month payment arrangement would be about as long as you would get.
Right, they're entitled to certain longer payment arrangements and other protections, but they just can't charge the survivor with debt accrued in someone else's name, but that doesn't mean that they can switch the debt.
Right. Yeah, exactly. Let's see. Okay, we're getting a lot of good questions. This is great. So did you want to go through the other couple questions that are there? There's the ERAP one.
I'm sorry, I'm missing it.
Oh, no, that's okay.
Feedback from some clients that landlords collected the ERAP funding, but then increased clients' rent, sometimes doubled it, or decided that some clients were no longer permitted to live in the premises. Is this legal?
Unfortunately, generally, yes. There is not a lot of protections for tenants in Pennsylvania law. There may be some more in specific cities. The only thing would be so each county has a sort of a vendor agreement regarding the ERAP fund. So they may have some requirement that they can't evict for 30 days or can't evict for 60 days or something like that. But the protections aren't great. And quite honestly, trying to actually take advantage of the rights that you have is tough because you need to, it's better if you have an attorney for landlord tenant issues, but landlord tenant attorneys are very, very busy. I would refer, if this happens, if someone's under threat of eviction under these circumstances, I would refer to the local legal aid. I think is probably their best bet. And increasing rent is tough because they're allowed to increase rent. They have to give, proper notice. I think it's 30 days, but yeah, they can do it. There's not a lot of restrictions on it. To be completely honest, I'd say your first stop is going to be your local legal aid for a landlord tenant attorney.
Thanks, Lauren. And then this other participant has a client where there were two names on the account. The account was closed. The agency was trying to get past bills, detailed ledger to assist with payments. The electric company refused to give information needed because they said they needed authorizations from the other person on the account as well. Their client no longer has contact with the second person. How can they work around this? Their program is required to have individual monthly amounts as opposed to the total amount owed.
Yeah, I believe I actually ran into this issue a couple days ago, earlier this week, and I think I requested that the client reach out to me directly. I don't know that the electric company is. If there is a active PFA that should, or other court order that, and the utility isn't aware of that, they should be made aware of that immediately. Other than that, yeah, I would be happy to reach out to the electric company on behalf of the client. I think that's something we could do we could probably get some information fairly quickly. But I would need to talk to the individual. So if they can reach out to me again, we'll have our, all of our contact information at the end here. So that's something I would want to help with on a one-on-one. I don't really have like a global answer to that question.
Right, and I can put our pulp email in the chat too.
Yeah. So just feel free to send an email, reach out directly, and we'll go from there. If I'm going to open a case and reach out to the client or reach out to the utility, I would need to talk to the client directly. Okay, so we'll go back here. Payment arrangements. There's two kinds. So there's payment arrangements you can get from the companies, and then payment arrangements you can get from the commission. So you want to use the ones from the utility first. Generally, they'll give you a couple options, although I'm not sure they necessarily have to. I think they can give you, they are required to give you one. Usually they would give you up to two. So this would be, you know that you owe the money, you've just fallen behind on your bills, and for whatever reason, enrolling in a customer assistance program is not an option for you. Maybe you were enrolled previously and can't defer that debt again, or maybe your income has changed and you're slightly over now. In any case, if you can't enroll in the customer service program, you can enter into a payment arrangement. Oftentimes that's tough, right? Because if you fell behind, it's because you couldn't afford your regular bill. And the payment arrangement is going to be a regular bill plus an additional amount. So, if it's tough. It is an option and it can keep you going for a couple months. And sometimes we recommend, if you can swing the payments for a couple months, maybe LIHEAP is then opening up again soon, or maybe there are other grant assistance programs that you can take advantage of. So I don't know how often payment arrangements are a great long-term solution for clients who are already significantly payment troubled and living below the 150% FPL or significantly higher, could still have a lot of issues trying to cover all their expenses. But it is an option for you. Just try to be sort of smart about how you use it. If you've already gotten a couple payment arrangements that you've defaulted on from the utility, you still have the option of getting one from the commission. There are various reasons that the utility commission would not issue you a payment arrangement, including if you have previously deferred arrears who have come back due. So it's sticky, it's technical, it's annoying, but if they cannot get a payment arrangement from the utility, they can call the commission. You're going to file, or you can do it online, file an informal complaint. The commission will reach out to the utility, get the account balance, and then they'll issue a decision. And that decision will either be a payment arrangement or it'll be the denial of a payment arrangement. So generally, people will get their second or third payment arrangement will be through the commission. But I always do, I'm very clear with my clients that if they fall behind on this payment arrangement, there may just not be another option. Then you may be looking at, declaring bankruptcy or, or some other option. And again, noted here, utilities have discretion to offer as many payment arrangements as they want for any length of time. There's no upper limit on how many they can offer. There's just a minimum of the number that they have to. But again, you're just talking about one-on-one advocating there and seeing what you can do for your client. Medical certificates, I think these get misunderstood a lot. So you can get a medical certificate from a household member. It can be a doctor, CRNA, physician's assistant, someone like that. The healthcare office would send, it's a short form, we have it available, and it's available on the PUC website as well. It's a short form the doctor would fill out, send directly to the utility, which would either prevent a termination for 30 days or restore service if it's been within 30 days that service was cut off. So they don't need to provide a specific diagnosis. All it really needs to say is that this person has a medical condition that requires the use of whatever utility, is at risk of being terminated. And the utility doesn't get to say yay or nay, right? Like it's up to the medical professional whether this is a qualifying condition. However, you can only use a medical certificate 3 times for any given chunk of debt if you don't make any payments. So what that means practically is if you need a medical certificate to restore your service or to maintain your service, it's not really a great long-term plan, because what you need then is for your doctor to be willing to submit it every month, every 30 days, and you need to be able to pay all of your current charges by the due date. So the current charges are high, payments are high, bills are high. So, if you want to renew this over and over and over again, you technically can, but again, that client is going to have to pay those current charges fully on time every month in order to be able to keep renewing that MedCert. Otherwise, they can renew it up to 2 times, so a total of 90 days of protection. But again, a lot of clients don't remember that they used one in the past. So what we'll run into a lot is they said, oh, I think I used one before. And then I reach out to the utility and they used 3 or 4 and they just don't, that's just not an option available to them at all. I realize I'm telling you that like everything is a bad option, but you cobble them all together. We've been pretty successful at keeping people on. And then specific tenant protections, I'll try to speed up a little bit. I know I'm chatty. There's parallel statutes here. So whether you're talking about a regulated utility or an unregulated utility, tenants basically have the same kind of chunk of rights. So basically what this means that if the landlord stops paying the bill, you as the tenant have the right to pay the last 30 days of charges to keep service on without putting service in your name. If you are a tenant, you should never assume the debt of the landlord. And we know that this happens because a lot of the utilities, especially the unregulated utilities, will try to dump the entire debt of the landlord onto the tenant in order for them to maintain their service. They're not allowed to do that. You can maintain your service by paying just the last 30 days in full, on time, indefinitely, without putting service in your name. And let's see what other the specifics are. Yeah, so there's a little bit of difference here. So generally this happens that the landlord is the utility's named customer. He just stops paying the bill, or sometimes the utility they'll call the utility to try to terminate service at the residence in order to do like a constructive eviction. So just another way to try to get the tenant out. So if this sort of thing happens, you know, call to your local legal aid for a landlord tenant attorney, call the utility directly, make sure that they know that you're a tenant and that they have to allow you to pay the most recent charges in order to maintain your service. So landlord tenant attorney, utility directly. If the utility is not cooperating, and I know that some of them don't, call us. So you also get notice requirements, right? So if the utility is in the landlord's name and it's going to be terminated, the utility has to notify the tenant. So at the actual, you know, the residence, and you have to pay. You can deduct those bills from your rent, and you know, keep track of your paperwork. You know, pay with a paper trail if you can. So you should be able to deduct that from rent. And then if the landlord tries to evict you for falling behind in your rent, you have a really, really good case at the magistrate. That's what the protection from retaliation is. They can't get you out for that. And then, yeah. So we talked about the right to deduct payment from rent owed, no retaliation. I mean, of course, landlords will retaliate, but you know, you have a pretty good case there. Protection from constructive eviction and waiver prohibited. What that means is that it kind of, with these rights, it does not matter what your lease says. Those are unenforceable clauses if they are in your leases. Foreign load, this comes up a lot in apartment buildings. So a foreign load, just, you know, easiest description is, you know, you rent apartment 3, you pay for the bills in apartment 3. However, it seems like your bills are really high, and it turns, and you think maybe I'm paying for the hallway light, or maybe I'm paying for common space or someone else's apartment. Call the utility directly, request a foreign load investigation. They'll come out, flip breakers on and off, figure out what's going on. If there is a foreign load on your bill, they have to shift the bills back into the name of the landlord until they get it sorted out. And you're not responsible for those payments while they're sorting them out. So again, if you think something like that's going on, and again, that happens a lot, especially in older buildings, it may not be that the landlord is intentionally doing it, but they may just not know. I see a quick question in the chat there. If the tenant doesn't have a lease, oral leases are leases in the state of Pennsylvania. So you don't need a written lease. It's helpful. Definitely encourage a written lease if you can get one, but that's not the only way to establish tenancy in Pennsylvania. So an oral agreement is a lease. Let's see.
Right. Another time foreign load can happen is, say, perhaps they have like a shared basement laundry or something like that, and it's put on one of the tenant's accounts rather than a separate account paid by the landlord or whatever it may be. We have another question in the general chat. Which counties do we cover? We cover every county, all 66 in Pennsylvania. And is it true that employees from the agency supporting such needs to their own clients don't qualify for all this help? I'm asking for a little bit more clarification on that, but I think the answer is no, that's false. If I'm understanding correctly, which is that if you work at one of these agencies that assist clients, that if you would qualify otherwise and be eligible for it, income eligible, everything else, you would qualify for these utility-based or federal assistance programs.
Yeah, completely agree. There would be, if you're otherwise qualified, your place of employment should absolutely not bar you from participation. So we talked about complaints. So if you can't work things out directly with the utility, you can call the Pennsylvania Public Utility Commission. You can file an informal complaint. You do not need an attorney to do that. You do not need representation to do that. It's a straightforward form online, or you can call. We have the number here. If you file before your service is terminated, that will temporarily stop your termination. So, I mean, when people are getting down to, well, I get paid on Friday, I can't get another extension, sometimes it can be a useful tool to delay termination slightly. But the outcome of that is that you will get a payment arrangement. And if you cannot keep up with that payment arrangement, you don't have a lot of other options after that. So, I've used that as, assistance for people who, were out of work for a few months and just started working and have not gotten paid yet, but will be able to keep up once they start getting regular paychecks. It's not a long-term solution. And formal complaints, rarely do we have formal complaints. But if you, appeal, if you're not satisfied with your informal complaint decision, you think that they missed something, they made a mistake, you can always appeal and file an informal complaint. We don't generally represent people in complaints in front of the PUC. That's just not, we generally will only work between the customer and the utility directly. Oh, good, just made it. So for consultations, or if you need assistance with utility issues, you can send an email to the pulp at PA Utility Law Project. So that is not an email to give out to your clients. That is an email for caseworkers and, other attorneys and, anyone who is assisting people. Do not hesitate to ask with technical assistance, to reach out with technical assistance questions. We're happy to answer them. Utilities, I think our executive director, Liz, describes utilities as, an inch wide and a mile deep, meaning that, it's a small area of law, but it is so technical and needlessly complicated that, it's hard to navigate. So never hesitate to ask a question. And then if you want to refer clients directly to us, for example, the one electric company that you were talking about, trying to get some data from them, have that client call the utility hotline directly, or they can email the utility hotline. So the hotline is closed currently on Mondays and Fridays, just for capacity, because we're slammed. But an email will always come through. But if they call, Tuesday, Wednesday, Thursday, leave a message, we get back to everyone within 24 hours, if not the same day.
Right. So think of that first email, that first pulp at PA Utility Law Project.org for you guys, for advocates and attorneys to reach out to us that we can help you assist your clients. And that second phone number and email is one that you can provide to clients to refer them to our services. The hotline is for.
Yeah, and please do, because honestly, like a lot of the technical assistance questions we get is like, well, could you have the client call us? Because in order to open a case and talk to the utility, we need to talk to the customer. So, freely give the hotline number out.
Right. Certainly, because sometimes when clients call in, and they need help, they'll call the utility and then it'll spit out that automated payment arrangement.
Yes.
Not based
Good
on
catch,
particular circumstances. It's just they spit out a number that they can offer, and if they accept that, then sometimes the utility is setting them up for failure if they can't make those payments. We only recommend
absolutely
those payment arrangements to the utility if help is on the way. Say they're in the process of, they know their application is about to come through, or they're about to get a paycheck from that next job. You don't want to agree to a payment arrangement that they can't afford. There's other programs available for the utility, like the customer assistance program, to get that debt forgiven with each on-time payment if they qualify, if they're low income enough.
Yeah.
How much?
Sorry. Go ahead.
How much forgiveness is there with unpaid TAP, CRP, TAP bills? If you miss a certain number of payments, are you permanently kicked off the program? Is it different per utility? Yes, it is different per utility. So some utilities, it's you have to make 36 on-time payments. They'll forgive 1/36 of your total debt with each on-time bill. But
There's not an upper limit though. If you somehow have managed to accrue $10,000 of debt and still have your service on and were never enrolled in a customer assistance program, I mean, there's no upper limit to how much debt can be deferred through the programs. And generally, yeah, just like Gio said, like there are some utilities forgive over 18 months, some is 24, some is 36, and some have stay outs that like, if you get removed from the program for failure to pay, or you fail to recertify, you know, sometimes you have to stay out for 12 months. Others, there's no stay out period, but you can't redefer your debt. So it really varies company to company, and none of them are perfect.
And we stress this to clients when they get enrolled in CAP, that they need to make those payments on time, monthly, because if they do miss them, that debt that was deferred comes back and it is due.
Yeah, like immediately. Like you will get a bill for everything that was deferred and not forgiven the next month.
Right. So if they miss those payments, it's a steep consequence for that. So they need to try to keep up with those CAP.
Yeah. And like I said before, I'll say it again, enrolling in CAP and deferring your balance and getting your discounted bill is the best case scenario for a low income customer. And so they really just need to do their best to keep up with the bills, even though we understand it's hard, and apply for LIHEAP every year.
Thank you. Thank you to all the panelists. I hate to cut it off, but we are at the hour. So I want to, again, thank the panelists for being here and providing all that really crucial information, and for all the lively back and forth with the Q&A with our attendees. Thank you so much. And as I mentioned, we will have the recording and slides to you next week. Have a great weekend, everyone.
Our pleasure. And those are our contact information.
Yeah, our personal contact info in case anyone needs that. But I think you're sending out the slides, right?
Mm-hmm.
Yeah, so perfect.
Thank you.
Thank you.